It's my pleasure to be chairing this session, not only because of its importance, but also because it's two friends of mine who I'm talking with this afternoon, which is really lovely as well. So I'm joined in this panel on Treaty with First Nations People by Professor Tim McCormack and Dr. Michael Gertzoni. Michael is a colleague of mine in the School of Social Sciences and someone whose ideas and knowledge have been more than valuable to me in my role as the coordinator of the Bachelor of Justice Studies, and particularly when one thinks about that one of the pillars of that Bachelor of Justice Studies concerns Indigenous justice. And I always welcome Michael's input and insights into this particularly important issue. My relationship with Tim has been long and fruitful in lots of ways. My first contact with Tim was with his expertise in international criminal law and international humanitarian law, and Tim's role as a special advisor to the prosecutor of the International Criminal Court. Now Tim is in a new but arguably equally important role as one of the members of the committee advising the government on a treaty with First Nations people here in Australia, here in Tasmania. So welcome to both of you.
Thanks, Matt.
Thanks, Matt.
Did I get that title right? Sorry, Tim.
Yeah, more or less. The Premier appointed the former governor, Kate Warner, and me to facilitate consultation with Aboriginal people around the state to understand what they want to move forward towards a truth-telling process and a treaty with the government. So yeah, it's good. You did well.
And so we have a number of questions that have been sent in by students. So I'll relay those to you, and I'll leave it to you to decide in which order you would like to answer them and how long you would like to spend. But I think at some stage in this conversation as well, I think it would be really important for us to talk about what a treaty looks like. And I know from the work that you do, Michael, and the conversations that I've had with you, what some of the hurdles to reconciliation are and what they look like, and questions around those ideas of healing that you and I have had personal conversations about, but hopefully we can perhaps have a conversation about that in our time. So the first question we have today is that would a statewide treaty or individually tailored Indigenous group treaties across Tasmania be more effective?
Just given the subject matter, Matt, I'm sure at the start of the Lawfest panels, you would have acknowledged the traditional owners of this land that we inhabit, that we're lucky to call home.
We did indeed, Tim, and we had a very emotional welcome to country to open up today's proceedings.
Yeah, I'd really like to start off this session, since I wasn't part of that welcome to country. I really like to start off with an acknowledgement of not only Michael as an Aboriginal man, but also of the traditional owners across the state. So today I'm in Hobart, and I acknowledge the Muwinina people as the traditional owners and custodians of the land that Hobart sits on. But I know that students who are watching into this session will be all around the state. Michael's at home on the Eastern Shore, so that's a different group, and others around the state are on the traditional lands of other tribes and clans in Tasmania. And it's really important for me to acknowledge, particularly in the current role, that ownership and sovereignty over this land was never ceded to the colonial government. And when we make an acknowledgement like we do, and like I am doing, I am acknowledging that sovereignty predated colonial invasion and dispossession. And that's one of the things that hopefully a treaty might rectify in some part, not to take us back to 1803, but to rectify some of the wrongs that emanated from that failure to acknowledge pre-existing sovereignty.
And so this is a really important point you made, Tim, and sort of our segue to the question is not only the importance of sovereignty and the importance of but also the importance of the groups in Tasmania as well. And that this has to be a reconciliation and an apology that covers all of those varying groups as well. And so I guess, so back to the question, is a statewide treaty, does that acknowledge the particular suffering, or does it acknowledge that there was different, perhaps, suffering of groups in Tasmania?
Michael, would you like to start off with answering the question, and then I can say some other things after that?
Yeah, thank you. I think with these things, both can work. And I think what the important thing is that all people have access to treaty and have their voices heard. One concern with having it individually is that it would be with organisations, potentially, rather than groups of people. And with that comes the point that reasonable time would be needed to be apportioned to each group so that they can present their case, as it were, and to have their interests met and heard. But on the other hand, I think a state-based treaty would understand the fact that the landscape of Aboriginal people in Tasmania is not as it once was, as the product of colonisation. And so that it would be seeking to make amends, reparations, and move towards reconciliation with the framework that exists to date. I think one concern with looking at different groups maybe is the fact that some groups are larger than others, some have more resources than others. And so this means that not only can potentially some groups make more arguments for certain benefits than others, but it might mean that smaller groups might not have the time or resources to make requests and recommendations. There's some things that come to mind, Tim.
Thanks very much. So, Michael, I agree with Michael's point about the fact that the landscape of Tasmanian Aboriginality, or the Tasmanian Aboriginal community, is different now than it was in 1803. And there are particular aspects of the consequences of colonial invasion and dispossession in Tasmania that make it unique or very unusual around the country. So I acknowledge the Moonina people as traditional owners of the land that Hobart sits on. In fact, their country extended from Bridgewater in the north down the Derwent estuary and inland to the Mount Wellington and the Wellington Ranges, all the way south to around Kettering. Now, the Moonina, so violent, so overwhelming, so comprehensive was colonial dispossession in this part of Tassie, that there are no longer descendants of the Moonina. So when I would give it an acknowledgement of them as the traditional owners of this part of Tasmania, I can't also acknowledge their elders present and emerging. I can only acknowledge their elders in the past. Now, that doesn't mean there are no Aboriginal people living in Hobart on the land of the Moonina, because the Aboriginal people who survived colonialism were concentrated in the northeast and on the islands in the Furneaux group in Bass Strait, and from them their descendants have moved to, well, right across Tasmania. And Michael's own ancestry is from the Trawulway people in the northeast of Tassie, but he lives in Hobart, as do many others. So that sort of does raise questions about who is the Tasmanian government to negotiate a treaty with in terms of Tasmanian Aboriginal people. I think that this question, which I'm really pleased that one of the students has thought to ask it, is a very interesting one. In Victoria, for example, they're a few years ahead of where we're at in Tasmania in terms of the process towards negotiation of a treaty between the Victorian state government and the Aboriginal people of Victoria. And what they're talking about at the moment, because they established what's called a First Nations assembly, a group of elected members by Aboriginal people across the state to represent those various groups and nations, and to be the representatives of Aboriginal people in Victoria when it comes to the negotiation of a treaty. There's some discussion going on in Victoria about what the treaty might look like. Will there be a single treaty for the whole of Victoria? Will there be multiple treaties with various groups or nations of Aboriginal people? Or could the model be a combination of those? So an overarching treaty that deals with various issues that are relevant across the whole of the state, and perhaps sub-treaties or sub-agreements with particular nations that deal with the local issues, and those local issues could include land returns, especially of Crown land in the areas occupied by, or the traditional lands of those nations. Now, I also agree with Michael that one of the challenges in Tasmania is that there is no organisation that represents all Aboriginal people in Tasmania. There are a number of organisations around the state, one of them much bigger than all the others, and the others in varying sizes. But there is a question about where land that could be earmarked for return to Aboriginal people, who should it be returned to? Should it be returned to an organisation? Should it be returned to the local mob in their particular area for them to care for and manage and heal where the country needs healing, to use for cultural practices, to be able to use for education of non-Aboriginal Tasmanians in that part of Tasmania, to be able to possibly exploit resources, use for tourism or create other industries on that land that would generate an income for the local community. So these are issues that will have to be sorted out in the future, and it's certainly not for Kate Warner or I to say to the government, this is how you should do it. Our job is to report to the Premier and through him to the government about what Aboriginal people around the state are saying to us their preferences will be. And at some stage down the track, when negotiations between the government and Aboriginal people happen, then these are the sorts of issues about form of treaty as well as content that will have to be negotiated.
Michael, do you mind talking a little bit about what the benefits of a treaty are in relation to other forms of reconciliation, please, and sort of whether this is a complementary procedure a complementary aspect to overcome injustice, whether it's something that stands alone or with other aspects of reconciliation, please?
Sure. Thank you, Tim, and thank you, Matt. So as many of you students know, one of the ongoing issues in respect to treaty is the question of sovereignty and the question of the past and whether amends have actually been made. So over time, we've seen that there's been an apology by our federal government to the Australian Aboriginal and Torres Strait Islander people. But some, I think quite rightly, make the argument that words are cheap or symbolic, and there's need for further action to be made to rectify or ameliorate some of the underlying issues that are the consequence of colonisation. And as we know, Indigenous Australians suffer from disadvantage economically, in health and in education. And so treaty seeks to provide a number of benefits to address some of these issues. Self-determination, for instance, is one which has been pushed by a lot of academics and activists, and that's the idea that Aboriginal and Torres Strait Islander people are the masters of their own fate. And so in terms of treaty, it gives opportunity for that to be given back through the provision of land, by acknowledging that the land was taken and by giving it back over for use and particularly cultural use, but But also there's been attention to some of the other benefits, such as a renewed focus on providing healthcare for Indigenous people, access to housing, for example, and really working to support Aboriginal and Torres Strait Islander people in education. And so these benefits collectively, alongside the provision of land, access and control, seeks to work away some of those historical issues of which have been given by colonisation. And from that support, there's the hope that there will be intergenerational benefits. So more Aboriginal people going through to university, and agree, university is not for everyone, but we do see that there are benefits of higher rates of employment, higher income, and affirmation of the importance of education so that subsequent generations complete their schooling and can enter secure employment. And from that, you have a number of economic and health benefits as well. And so I think that for movements to reconciliation, it cannot rest with symbolism alone. And yes, symbolism is important, but there are a number of other consequences of colonisation which need to be addressed. And I think the treaty will seek to do that.
Tim, did you want to add anything to Michael's comments?
Yeah, I really like Michael's. Thanks, Matt. Thanks for the opportunity. I really like Michael's comments. I would add that I think we've had some feedback, Kate Warner and I, that framing our responsibility, our project on behalf of the Premier in terms of reconciliation is the wrong framework. Because reconciliation, to say that we're working on identifying a pathway to reconciliation, imposes on Tasmania's Aboriginal people a certain outcome, which they may not want. And we've had that feedback from various people and groups that we've met with in Tassie, but also from our colleagues in Victoria, because we've been trying to educate ourselves about what the other states are doing, Victoria in particular, WA, Queensland and Northern Territory. And one of the questions in the Victorian colleagues is, how come it's all framed in terms of reconciliation? We're not doing that here. We're framing it in terms of self-determination, autonomy, the freedom for Aboriginal people in Victoria to determine their own future and their own destiny. And if that means that they want reconciliation with white Victoria, well, that's great. But, it's for them to decide that rather than pre-deciding it for them. I found that very helpful. I think it's really good to be challenged about, are you actually intending a particular outcome that's a precondition for making progress, or are we going to say to Tasmanian Aboriginal people, you decide what your future will be, and if that means that if your choice, your decision is about wanting to walk this pathway together, fantastic, because there'll be people who are non-Aboriginal who want to do that in a sort of collaborative way. So yeah, I think that one thing to say for sure about negotiation of a treaty is that a government, the state government of Tasmania, choosing to do that has to be sitting down with the representatives of the Aboriginal people, whoever they're going to be, to treat them as equals in the sort of sense of equal sovereigns, to talk through what the content of the treaty should be. That will be a major advance on what hasn't happened in the past.
So Tim, following on from your comments, and this is for both of you as well, so we've sort of addressed what the positive aspects for treaty and other forms of reconciliation that Michael also mentioned are. Is there discussion in what you've been doing, Tim, and also Michael, perhaps in conversations that you've had, but also perhaps theoretically, are there negative aspects of treaty, or are there negative aspects of some of the forms of reconciliation that we've been talking about as well?
Yeah, I'm happy to kick off, Michael, if you're happy for me to do that. the fact is that a number of people have said to Kate and I, we're wary of what might be included in the treaty, because those people have heard about treaties between, for example, the federal government of Canada with First Nations peoples in that country. And the sorts of issues that have come up in some of the treaties in Canada, as I understand it, I'm not an expert on Canadian treaty law, but this is, we've done a little bit of research on this, having sort of been tipped off about it. But the sorts of concerns that have arisen involve where a treaty's been negotiated and a particular First Nations group has believed that that means they are regaining sovereignty over the land that might be returned, only to discover that a mining lease or a forestry lease or possibly even a pastoral lease trumps their ownership or their freedom to determine how the land should be used. And so a number of people have said to us in Tassie, don't let that happen. We don't want a treaty that we find that gives significant land returns back to Aboriginal people, only to discover that some mining company has the right to start to engage in exploration and or extraction practices that we may consider are totally inconsistent with our sense of what it means to care for country. And that would be diabolical for us. So, yeah, there are potential negatives with treaties, in terms of precedents around the world, and it'll be very important for those representatives of Tasmanian Aboriginal people who sit down to negotiate a treaty with the state government to be able to say what they're prepared to accept and what they're not prepared to accept, and see whether there can be a meeting of minds on that.
Michael?
Yes, thank you. I totally agree with what you were saying, Tim, and that was going to be my point as well. It can be said that we would not want it to be land native title in disguise. It's treaty ought to include, in my view, sovereignty as well. And that brings a number of other complications. In terms of custodianship and care, you can give land back to people, but there is need to perhaps to also give them resources, whether that is starting out or for a period of time, to then care for that land. And I can only imagine the example that comes to mind is perhaps part of, and this is purely hypothetical, of course, certain land is given back to a certain community. They don't have the resources to look after the land, and bushfire season comes around and they can't control it, and it then burns over into private land. We can only imagine the criticisms that would be laid against that community group there. So I guess they're the things that come to mind, apart from, as we mentioned earlier, some of the Aboriginal communities no longer with us, so the Muwinina people. How would that sensitive issue be discussed? Would only certain people in Hobart be able to, have custodianship, or would it be shared to all Palawa people, as often is the precedent now that the Muwinina people aren't here? There's focus to the Palawa people as a group.
Perhaps I could just also add, as Michael was talking, thinking about some of the feedback that Kate and I have received, been quite a bit of discussion about in relation to the land returns that have already occurred in Tasmania. So that was sort of first initiated by the government of Ray Groom, Liberal government in 1995, where 12 separate parcels of land were returned to the Aboriginal people. And then there were a couple of additions in 1999, and then some more again in 2005. But there were never any rights over water, either freshwater or saltwater, in addition to the parcels of land. And one of the things that a number of members of the Aboriginal community have said to us is that in relation to the negotiation of a treaty and possible future land returns, This time we're going to insist that there are also rights over waterways, access to fresh water, which could be a resource, and also access to the ocean, maybe not the full exclusive economic zone, 200 nautical miles out from the low water mark, but to be able to undertake cultural fisheries, for example, is a really important aspect of Tasmanian Aboriginal life, and to be denied that because, you know, in the returns of land that border the ocean, and there have been quite a few of those, including the islands in the Furneaux group that have been handed back. Commercial fishers, so I'm talking about cray fishermen and abalone fishermen, still able to take their commercial catch right off those islands, and that's very frustrating when commercial cray fishing people, I shouldn't say fishermen, come along and take 60 tonnes of crayfish, and Aboriginal people from Cape Barren Island or Babel or Chapel Island or Clark Island or Big Dog Island no longer can just go diving in the water to take a cray because they've all been fished out. So, you know, there are a whole lot of issues that have come up in the past that we perhaps didn't think about at the time and will need to think about in the negotiation of the treaty.
I'm keeping half an eye on the time, sorry, and I know we're coming up to the end of this session, and with the other sessions that I've chaired today, I sense the material and the interest from students and the passion that our panellists have been able to display. We could go much longer. What I think we've been able to do in this half hour is be able to sort of identify both the pros and cons, the complexity of this issue. And as we sort of mentioned at the start of the day, what we hope you're able to do with respect to all of the issues that we've discussed today is engage with that complexity, that this is the issues that we have spoken about today are complicated. They have multiple informing factors to them, and our panelists have been able to address some of those, and we encourage you to sort of get down and dirty with a lot of those factors as well. And we hope you are able to do that, and we hope that the sessions today have been able to facilitate you doing that. Please join me, at least virtually, thanking Professor Tim McCormack, Dr. Michael Gertzoni. Thank you both to you so very much. That was a really enlightening, engaging panel discussion.
Yeah, thanks, Michael. Thanks, Matt. Good luck to the students.
Thank you very much.